paper is a law that supposedly governs ticket reselling. It has been on the books for nearly a decade. And yet paid communities that teach people to buy and flip tickets keep operating in plain sight, charging monthly fees, advertising the income, almost never getting touched. That is not an accident. It is the direct result of what the law actually says, what it pointedly does not say, and how rarely anyone has bothered to enforce it. So we pulled the statute, the enforcement record, and the recent crackdown and read it back to front. This is an audit of the Bots Act and the gray zone it leaves behind. Start with the text, because the text is narrower than the name suggests. The Better Online Ticket Sales Act, signed into federal law in December of 2016, does exactly two things. First, it makes it illegal to circumvent a security measure, an access control system, or any technological control a ticket seller uses to enforce posted purchase limits for any public event with a capacity above 200 people. In plain terms, that means deploying bots or buying under fake identities at scale to blow past the 4 or 6 ticket limit a site has set. Second, it bans reselling a ticket you obtained that way if you participated in the circumvention, could control it, or should have known about it. That is the entire prohibition. The law is not aimed at scalpers as a class. It is aimed at one tool, the automated software that defeats a purchase limit. The part that matters for anyone evaluating a paid reselling community, what the law does not touch. It does not ban reselling tickets. It does not ban buying a ticket and flipping it for a profit. It does not ban buying many tickets as long as you did it the way the site allows, by hand within the posted limit. And it does not, by itself, cap the resale price. Reselling above face value is legal across most of the United States. Only around 15 states regulate it at all, and the rules vary wildly. New York caps a markup near 10% over face. California requires a license to sell above face, and the rest mostly leave price alone. So the federal law targets the bot, and the bot only. Manual buying and reselling. The thing most of these communities actually teach sits in a wide gray zone no federal statute clearly forbids. The law is only as real as its enforcement, and here the record is stark. The BOTS Act was signed in late 2016 and handed to the Federal Trade Commission. The commission then brought 0 cases for more than 4 years, not a single action until January of 2021. For the entire stretch, when bot-driven scalping was at its loudest, when fans could not get near a major on sale, the agency holding the only federal tool used it exactly never. The penalty on paper was real. Violations are treated as unfair or deceptive acts under the FTC Act, carrying a civil penalty that started around $16,000 per violation and, with inflation adjustments, now sits above $53,000 each. But a serious number that goes unenforced is just a suggestion. For 4 years, the BOTS Act was a sign on an empty road. Enforcement finally arrived. It arrived narrow. In January of 2021, the FTC brought its first ever BOTS Act cases against 3 New York ticket brokers. The allegation was textbook. They had used bots and other technical tricks to grab more than 150,000 tickets to popular events the moment they went on sale, then resold that inventory for millions. The combined civil penalty judgment came to more than $31 million. And here is the detail that tells you how this law really works. Because the brokers claimed they could not pay, the court suspended most of it. They actually paid about $3.7 million total across all 3 operations. So the very first time the government used this law, the headline was $31 million and the real collection a fraction of it. 1 sweep, 3 defendants, and that was the entire enforcement history for years. Step back and the timeline reveals the shape of the problem. The law passes in 2016 with bipartisan support and real intent. Enforcement does not begin until 2021. Then, recognizing the gap, lawmakers try to strengthen the regime. The Ticket Act clears the House in 2024, aiming at fee transparency and resale rules, and senators introduce updates to give the FTC sharper tools against bots. In March of 2025, an executive order directs the commission to, in its words, rigorously enforce the BOTS Act, alongside state attorneys general. The arc is unmistakable. A law written, then ignored, then belatedly tested, then politically rediscovered nearly a decade later. The gray zone these communities live in was not designed. It was carved by the silence between passing a law and using it. And the silence may finally be ending which changes the math for anyone buying into a flipping community right now. In August of 2025, the FTC sued a Maryland broker operation, Key Investment Group, doing business under names like Epic Seats. The allegation BIST used illegal tactics to work around Ticketmaster's limits and obtain nearly 380,000 tickets between late 2022 and the end of 2023. It spent about $57 million buying them and resold them for roughly $64 million. For a single Taylor Swift Eras Tour show, the FTC says it used 49 separate accounts to buy 273 tickets, against a posted limit of 6 per person. The defense is revealing. The company argues it used no automated software at all, no bots, and so did not violate the act. Whether 49 accounts and 273 tickets counts as circumvention without a bot is now the question a court will decide. And the answer will define how wide the gray zone really is. So here is where it lands for someone weighing a paid ticket reselling community. First, the legal reality is sharper than the marketing admits. Reselling tickets, even at a markup, is legal in most of the country. But the moment a method depends on defeating a purchase limit, bots, automated checkout scripts, or armies of fake accounts grabbing inventory, the platform tried to cap, you have crossed from the gray zone into the one thing the BBots Act was built to punish, with civil penalties now exceeding $53,000 per violation. Second, what these communities are really selling is the gap between those two states. They teach speed and scale, and they survive on the enforcement drought that made the line feel theoretical. Third, that drought is visibly ending. 2 enforcement waves in 5 years, an executive order demanding more, and a live court fight over whether dozens of accounts count as circumvention without a bot. The question before you pay isn't whether reselling is legal. It broadly is. It's whether the method they teach depends on beating a limit the seller set. If it does, the law already has a name for it, and the gap that protected it is closing. Audit closed.